Good morning. I'm Maria Francesca Corradi, lawyer and mediator in Rome, and I'd like to introduce you some recent reforms in family law. Italy has been trying for a long time, especially in the last 5 years, to cope with the demand of justice advanced in various areas from the citizen. Judicial structures and the instrument of the process accuse the overload of cases pending that make it difficult to dispose of previous litigation and also slow down the performance of the new processes. For this reason, with different intervention from 2010, in order to eliminate the backlog of civil proceedings pending, have been introduced ADR tools: civil mediation, mediation assisted by lawyers, and finally arbitration and assisted negotiation, with the decree number 132 12th of September 2014 converted with the law 162 the 10th of November 2014. These laws are part of a legislative frame that already included other forms of extrajudicial conciliations, for example in telecommunications, consumer protection, banking, etc. In general, the use of these tools has been limited until now, either by the lack of knowledge among the general public, either by an aversion on the part of lawyers to use such procedures. In chronological order, the very last law passed, the number 162 in force since 11th November 2014, has emphasized the function of lawyers, including the possibility and in some cases the obligation to proceed with the assisted negotiation. In this section, we limit the exposure to the rules for the mutually agreed separation, termination of the civil efforts of marriage, of changing the conditions of separation. Article 6. These provisions have already come into force upon publication of decree number 132, then from 13 September 2014. With the conversion of the decree, law has extended the use of assisted negotiation even to unions with minor children and older, unable or severely disabled or economically dependent, effective from 11th November 2014. The procedure of assisted negotiation is essentially the signing by the parties of an agreement by which they agree to cooperate in good faith and with loyalty to resolve amicably a dispute relating to disposable rights through the assistance of lawyers, and as well in the subsequent negotiation activity itself, which can lead to the achievement of an agreement signed by the parties and the lawyers who assisted them. This agreement shall be enforceable also for registration of judicial mortgage. There are two hypotheses of assisted negotiation under the new regularity intervention: optional or voluntary procedure and mandatory procedure. In family assisted negotiation, the procedure is optional and is governed by Article 6 of the above-mentioned law, which provides that this instrument could be used by the parties, at least assisted by a lawyer, to reach a consensual solution of separation, cessation of the civil efforts of marriage, or change in the terms of separation or divorce. Let's come to see the procedure. This, in general, the procedural process designed by the legislature for the Convention of Assisted Negotiation, both mandatory and optional. Article 2 and 3. First of all, when a lawyer is appointed, he must inform his client of the possibility of resorting to the Convention of Assisted Negotiation. Then the party chooses to try the new procedure, and the lawyer sends to the counterpart an invitation to enter into an agreement negotiated. Subject of the agreement. It must indicate the agreed deadline for the completion of the procedure. This should be not less than 1 month and not exceed 3 months. It's also subject to extension agreed by the parties. The subject of the dispute, which may not involve inalienable rights, nor as a debt during conversion, focus on employment. Be made in writing, on pain of nullity, with the assistance of one or more lawyers. Contain certification authorship of signatures to the convention by lawyers under their own responsibility. In particular, Article 6 stands: in the absence of minor children and older unable or economically self-sufficient, the agreement reached with the assisted negotiation must be sent to the public prosecutor before the competent court, which, in the absence of irregularities, communicates the necessary permit for the purpose of transmission to the state official for its record. In the presence of minor children, etc., the agreement is sent to the public prosecutor at the court who, if he considers it satisfies the interest of the children, authorizes it. The agreement must be submitted by each lawyer within 10 days in the registry for the records of the case, on penalty of filing of a fine from 2,000 to 10,000 euros. The agreement has the effect and take place of the court orders that define, in the cases referred to in paragraph 1, the process of separation, termination of the civil effects of marriage, dissolution of marriage, and change in the conditions of separation. This is the aim of this recent reform. Take the process out of tribunal. It is also important to remember that the agreement must refer to the following activities by the lawyers: attempt to reconcile the parties, communication of the possibility of family mediation, give to the parties notice of the importance for the child to spend adequate time with each parent. A particular attention is posed on confidentiality. The Article 9 of the law in question imposes the obligation to keep confidential information acquired in the course of the proceedings that cannot be used in the trial in all or part of the same object. And also participants in the legal proceedings cannot be required to testify about the content of the statements made and the information acquired. The violation of the obligations of loyalty and confidentiality is for the lawyer disciplinary offense in addition to the offense provided as a crime. The ruling in question, finally introduced with the Article 12, additional provisions for the simplified procedure for separation and divorce. Under this rule, the spouses may conclude before the mayor, with the optional assistance of a lawyer, an agreement of separation or dissolution or termination of the civil effects of marriage, as well as conditions to change separation. The provisions do not apply in the presence of minor children and older incapable or handicapped or not economically self-sufficient. The agreement may not provide for terms of real estate transfer or other kind of disposals. The officer of the civil estate, according to Article 12, paragraph 2, which received the request to proceed under conditions agreed, invites the couple to appear in front of him until 30 days of receipt for the confirmation of the agreement. The failure to appear is equivalent to lack of confirmation of the agreement. When the parties eventually, with the assistance of a lawyer, personally make any statement to the officer of the civil estate, the agreement is immediately completed and signed by the parties themselves. The impact of this reform is of considerable importance for all the protagonists in the world of law. Lawyers are and judges committed to implement the reform, and the parties more and more involved, even to take responsibility for their own choices in defensive strategies. The advocate necessarily has its function even out of court, and therefore has a more creative function while listening to the interests of all the parties, both of his client and of the counterparty, in order to cope with different needs. It will also be important to implement and adopt the professional training too. Judges are called to verify compliance with the legal conditions of admissibility, as well the conduct of the parties in the stage of pre-trial mediation or delegated mediation. Finally, the parties that have a role not only merely passive but rather active in setting their goals and finding solutions. The hope then is to reevaluate the system, making it faster but within the law and therefore of the confidentiality, in order to ensure the values of good faith and loyalty in the face of rampant impunity both in civil and criminal matters. Thank you. Goodbye.